I think a little bit of a background into the case. Not that I'm going to go into the substantive bits of it, but essentially what happened was the contract had a few clauses, some of which were to terminate the guy with notice, also that he would receive certain amounts of pay upon termination, and another was that they would be able to terminate him summarily if they discovered any sort of misconduct. That was built into the contract. They then sent 2 letters to the guy. The first letter that came out essentially said that your termination takes effect immediately, and also that you are being terminated pursuant to the contract. But then it never went into the details of which clause they were relying on, etc. So then came a second letter about a month later, and that second letter said, well, now we've discovered all these wrongs that you have done, you have made certain claims, etc. And so now we are summarily terminating your employment. So it went to court, and the decision that came out was that by virtue of the first letter, by saying you are terminating pursuant to contract, the company has elected to go down a contractual route of termination as opposed to a common law route of termination. And also that because that first letter said I'm terminating you with immediate effect, so there was nothing to terminate when it came to the second letter because termination had already taken place. So one of the issues that the court considered was, once you elect to terminate contractually, can you then do a common law termination later on relying on the same facts? There is a line of cases, Boston deep sea fishing line of cases, where if you summarily terminate someone based on reason A, for example, later on you discover other wrongs and you decide to rely on reasons B, C and D that you didn't know about at the time of termination, you can, because that is defending why you summarily terminated someone. But when you have elected a contractual route of termination, you can't change it into a common law route of termination later on. It's one or the other. So the takeaway point that we have from this case is that when you craft a termination notice, you have to be very careful about why you are terminating it and how you are terminating it. You shouldn't say, if you think you might want to summarily terminate this person on a common law route, you shouldn't say it's pursuant to the contract, because then you elect one path and you can't switch later on. So that's the essence of it. In terms of what employers should look out for, I think a carefully well-drafted notice letter is important, or termination letter is important, because you should set out what you're relying on, especially with regard to certain clauses, etc., so that it's clear. And you should be careful. And one of the things that we also encourage employers to do is to perhaps investigate these claims thoroughly before you jump the gun and do something, because then you might be locked into whatever you've chosen.